door. It's not our fault that legislation took so long. Yes, they've tried and they're busy with it now, but you can't blame us for it. And this has caused the demise of our industry. Daily we hear of people going out of business. When e-hailing arrived in South Africa, the acceptable way was to approach the existing industry, like I said earlier, and let us come on board, but come on board with a legal business, a legal operator. And this wasn't going to happen. The authorities in all spheres of government ignored our industry, and they've allowed the onslaught, hoping that we will fall and disappear, as they'd hoped with the minibuses in the BRT. But we're still here, some of us. Many taxis have joined the legal apps with legal operating licenses, and we fully support that.
Mr. Drummond, I just want to establish how long do you still
One more page, sir.
All right.
Right. The issue of the operating license is actually the heart of the matter. The City of Cape Town is compelled to do a needs analysis before issuing an operating license, and they need to determine how many operating licenses are required for that, or in Cape Town's case, for our city. The city approves your license and effectively says that we believe this city has a need for an extra XYZ number of operating licenses. So they've done, I don't know how they do it technically, that would be quite interesting to find out from them, but they've done a needs analysis, and by doing that, they've said that you can go out there and you can make a living with your operating license, because we feel that there's sufficient work out there. The needs of an e-hailing company, now, an e-hailing company's needs could be very, very different to a city's needs. And I think this is the case here. Whether it be Uber or Taxify, whoever else is out there, their needs, they want their 25%. And if they could put 10,000 cars on the road, they'll put 10,000 cars on the road. They're not worried about the driver or the labor issues or the regulations. But the city's needs are important, and we need to have a sustainable industry. And to willy-nilly just go out and issue permits, and I'm glad to hear what I heard from Lee today, that I think it was Lee that said that the city doesn't see this as a solution. And I think that's the reason why the city has not issued more permits for Uber and Taxify, is because they don't simply need them. They might not be able to say that, but I'm telling you now, they simply do not need them, and that's a fact. If a customer has to wait 10 minutes, tell the customer 15 minutes and reduce the number of operating licenses that they want to issue. It's not going to make any major difference to anybody, but it'll make a major difference to the drivers that are out there. These are the guys that are trying to make a living. Price surging, I've got two more points, Chair. Price surging, the issue of price surging is a regulated market. In a regulated market is crazy. And if you have total control of when and how much you adjust these fares, Uber used the Gautrain in their presentation and in some airline, but Gautrain, you can open up the Gautrain website and it'll tell you when there's going to be expensive fares. You can go onto the airline website and it'll tell you 6 in the morning it's going to be expensive. You don't walk into Gautrain and suddenly there's boom, it's gone red and it's a surcharging. It's informative, it tells you beforehand. So from my opinion, it's just crazy that they're allowed to do that. These are not prices that are changed in minutes and exorbitantly adjusted as you're about to board a plane or a train. And I would imagine that they also have some sort of a scale at which they're expected to operate within. Again, it goes back to the point of charging, that these apps can charge what they want, when they want, and at any time. It just depends on whether there's an algorithm that clicks in place and suddenly you got 3 or 4 times the price. And then I think it also was mentioned as well that, oh, well, don't worry, if the customer doesn't want to pay 4 times, then he can use another service. The way things are going now, there won't be another service, and you're going to have a monopoly. So the customer will be compelled to use the 4 times charges. And then just lastly, the route. The Uber presentation, I'd like to see a driver. Okay, I've actually gone over that, Chair, so I think I'll just skip that part. That was that, I think. There's one other point. Sorry, my last one, Chair. Just the solutions. And we just believe, I believe in myself, and I think a lot of my industry, I talk on behalf of them, that every taxi must have an operating license. They must be well marked. The NLTA must be enforced as a metered taxi. And then at subsection 66A, additional conditions need to follow, and we can live with that. The amendment allows e-hailing access to ranks, and that's one of the problems we've got with the NLTA, is that in the Act, they've just amended the third amendment, I think it was, where the change came in, where they said that e-hailing vehicles are allowed to be used at ranks, and that's a bit of a concern for us because we have ranks in Cape Town that are specifically given for that particular rank. So that would be infringe on those. For the fact of rates, we would like to see a set price. So if you want to go from 8 Rand to 20 Rand, that should be the rates, and no one should be allowed to go more or below that. Punitive action, we think that's a wonderful thing that the government is in LTA, and the fact that it's not picking on Uber or Taxify or e-hailing. Section 90 refers to A, B, D, E, and O, so it's not just e-hailing that's been affected. Sorry. This is the most important one, Chair, is the financial loss to the industry has been catastrophic, and this was a direct consequence of non-legal recognition given to the e-hailing operators. And as such, I call for the compensation for all holders of metered taxi operating licenses. This has been a deliberate effort to undermine the Act and the systematic demise of the metered taxi industry. Government paid over R1 million for operating licenses when the minibus taxis were asked to relinquish these operating licenses for the BRT because they were affected parties, Chair. We are affected parties. We were, we are, and we continue to be affected. And as a result of allowing the non-legal recognition of a public service, I request immediate negotiations to begin with regards to compensation. And we ask that the Commission would assist us in taking this further. I can call on the government to reinstate operating licenses to any person or business that has been lost operating licenses as a result of this. I also request with immediate effect that the government demand that any person, body or business locally or internationally immediately complies with the National Act and issues cease and desist orders, or notices I should say, to those that have publicly declared they are operating contrary to the Act, and any person or organizations they are aware of that is actively contravening the NLTA. Finally, I urge all spheres of government to provide for a compliant, a sustainable, and most importantly, a sustainable and a regulated industry that will provide the public with the best service possible. And in closing, Chair, I would like to thank the legislators, your Member of Parliament, Mr. De Freitas, who was here earlier, and his whole portfolio committee. They did a wonderful job, and they moved this legislative process forward. And they really took the time to hear all my calls, and we communicated often. They interacted with our industry, and they responded accordingly. This has been a tough 4 years for us, but no matter what, and how slow the wheels of government turn, they turn nonetheless. Thanks, Chair.
Thank you very much, Mr. Drummond. Evidence leaders, priority questions only.
Thank you, Chair. Thank you, Mr. Drummond. I think maybe just too quick, I just want to understand the, the process, and it is linked to the next question that I wanted to ask. You've mentioned that there was a moratorium, and based on various reasons and in, various decisions taken by the municipality. But what I'm more interested in is you then say that immediately there were 1,000 permits which were then given to Uber. So the question that I have is, these applications are advertised, right? Am I correct?
No, not advertised. The initial applications were given to Uber. What happened with Councillor, would be the city, so it would be Councillor Brett Heron. He felt there was a need, taking into account that we've just come out of a moratorium for 4 years, when many of us couldn't apply, newcomers couldn't come into the market. Along comes this new new idea, and there's no advertising, there's no request from associations. That's why I've mentioned it in my submission. There's no formal request. They don't have to apply. They just go into the city, and they were given 1,000 on the condition that they would only use credit cards. Seems a strange request, but nonetheless, that's what was the arrangement between the city and Uber at the time, that they would grant them 1,000 operating licenses. I think it's just over 1,000, on the condition that only credit cards would be used, not cash. And that wasn't from our request or anything. It was just something that they had thought of. That obviously changed very quickly, but there was no formal. No.
Yeah, and I think maybe that is where the confusion lies, in my from my part, because I was under the impression that they are advertised in terms of the law. They have to be advertised, and an opportunity has to be given to objectors to object.
Oh, sorry. Once they've been given the go-ahead by the city, yes. Sorry, they do. They go into the government gazette. That's correct. Sorry.
Yes.
But initially, to give them that 1,000, I thought that's what you're referring to. Is
No. I'm referring to the
post
yes.
being issued. Yes. Yeah, they do. They go before the government gazette, and we opposed 180 of those. I think most of them had my signature on. And in the end, we took one of those applications, one of those 180 applications, and we went to the Transport Tribunal with that one.
Yes, yes, thank you. And that was going to be my next question. So I want to understand the reason for the objection. Was it based on the fact that you've been told previously that the market is oversaturated, or was the reason that was raised for that particular, or for those objections, was it based on the fact that they could not be granted operating licenses under the category of meter taxi, operating licenses? So just to understand the...
No, the main concern for us was the creation of a new subcategory, which we have no idea where this came from, called e-hailing. It doesn't appear anywhere in the National Act, and it's going to appear now in the new Act, in the new amendment bill. But in the current Act, there is no place that says e-hailing. And on top of that, I just want to give you a little bit of background on that. So part of our complaint was, when you appear before the PRI to accept that operating license, so it gets the government gazette, you go before the PRI, you basically motivate why you want to do it. In the Uber applications of those 180, they are given a business plan by Uber. So it tells the PRI, the panel at the PRI, that you are going to be working for Uber. It's a business plan from Uber. You must be working for Uber. But these operating licenses that they're still issuing specifically says you must charge X rand. So whether it be 10, 12, doesn't matter. But we know that Uber charges surcharge. It specifically says you may not surcharge. Uber surcharges. It says you may not operate time. In other words, you can't charge a customer for the time, which is how Uber works. So Uber charges a rate, a base, a rate, and also for time. So it specifically says you may not do that. And these are conditions that were on those applications, on those operating licenses, and we opposed all those points, but we were turned away.
Okay, thank you. And
just before you proceed, Mr. Ngobeni, just a follow-up on what you have said, Mr. Drummond, about e-hailing not being part of the current, not being in the current legislative framework. I'm looking here at Section 1 of the NLTA, and it defines a meter taxi service as a public transport service operated by means of a motor vehicle contemplated in Section 66A is available for hire by hailing while roaming, by telephone or otherwise.
You are 100% Chair. Then what is the reason for creating an e-hailing permit? Why not just a meter taxi permit? And that was our argument. It tells you that you can do it in the Act. Not that it's an e-hailing operating license. It tells you under meter taxis, you can buy some, I think it says by other means. And that's what they use in the TAT argument. But that wasn't the argument. The argument was, why create a whole new category called e-hailing? In other words, you don't get it's called an e-hailing permit. It's not a meter taxi permit. So that is what the argument is. Why must you create a whole new category of permits? They should fall under meter taxis, end of story. And if you want to operate via cell phone, great. If you want to go by telephone, that's also great. But why create a whole new subcategory if it already exists that you can use a cell phone? There's no problem using a cell phone. We all use cell phones, and most of our clients use cell phones. But the fact that they went to the next step and created a subcategory called, or a subcategory permit, operating license called e-hailing permit, that's the problem. So because the Act clearly says you can use a cell phone. And then why didn't they just argue on that case and say, well, we can use a cell phone? But they specifically went away from the charter, from the particular practice note that I spoke about, and they decided to do a separate application called e-hailing. It makes no sense. It still doesn't make any sense.
Yeah, just on this, because part of, I think it's a C of the same definition, subparagraph C. It reads, is equipped with a sealed meter in good working order for the purpose of determining the fare payable that is calibrated for such fare or complies with any other requirements applicable to such meters. Now, what I am struggling with a bit is to reconcile this requirement in C of the definition of a meter taxi with e-hailing services.
Chief,
or is the app a meter?
No, well,
does it meet the definition of a meter?
Well,
a sealed meter?
No, you can't. If you're referring to the e-hailing, you cannot have a sealed meter. It's impossible. It cannot even be calibrated, which it also says in the Act. But if I just refer to the final decision of the TAT, and in hindsight, we should have taken this further. Maybe we should have gone legal, but we don't have the resources to do that. But in the TAT, on that very point that you mentioned, I forget who the chairperson was. Anyhow, the final decision, which was dismissed, our appeal, he actually goes on to say, and I'll just read it right from the release that he gave us, and he's referring to obviously the Uber application and the cell phone, and he goes on to say, which is actually remarkable, this serves the purpose, okay, I'll just go one line up to make, the information communicated to the passenger in advance before the passenger can accept the trip. The final tariff is then communicated to the passenger at the end of a trip. But here's the point, Chair, is this serves the purpose of a sealed meter and could therefore qualify to be a sealed meter since it can also be calibrated. That's unfortunately what we were dealt with in the TAT hearing. So
what is this, the reference to this serves the purpose of a sealed meter?
A cell phone. So he's, the chairman telling us in the TAT decision that as far as he's concerned, a cell phone can be calibrated because the rates can be set by somebody in the back office. And he's quite happy with the fact that it can be calibrated. I don't know where that comes from. I don't know how he gets to that decision. And as I said, we should have taken it further at the time, but we just didn't have the...
And how does one reconcile that with the requirement for installation at the traffic, with traffic authorities of a sealed meter?
Wow, it's a long story, Chair. It's as I say, you got to, if I must take my vehicle to the, right now, if I've got a new application, I want to take a new vehicle, or I've changed a vehicle, I bought a new car, I first going to have my meter installed at a technician, about 3,000 Rand, you've got to pay for your meter, you take it to the traffic department in Greenpoint, the guy comes downstairs, he assesses your charges, I think he even tests your wheel, maybe the size of your tire, to see if it's not going to make more money out of it. He also takes you for a test drive. He assesses that that 10 Rand is going to be 10 Rand a kilometer, end of story. You go upstairs with him, he seals the meter, gives you a certificate. Then you go back to your traffic, to your pre, who then does a full inspection of your vehicle to check that you got all the whistles, bells and whistles, and then only can you go inside and go and actually hand your documentation in. It's an expensive, laborious process, which everybody else in our industry seems to be exempt from, except us. And if I may just add on that point, we have these periodic meetings with the PRE and the city, and to discuss issues. I've given up on it personally, and the reason being is that we sit and we discuss these issues and these regulations and laws and the new amendment bill that's coming out and so on. And the last time I attended the meeting, I said, are we talking about the 1,400 legal guys that work hard for a living, got families? Are you talking to us, or are you talking to the 4,500 others that are out there running amok and who are not at all obligated to abide by any rules, laws whatsoever, but yet compete for our business? And that's what we feel is very unfair.
Mr. Ngobe, how long do you still need?
Thank you. I still have maybe 2 or 3 questions. Just a quick one on the question of the meter. Just my understanding, I think maybe you can assist here because you've worked on this for quite some time. I'm just looking at the legislation. If you look at Section 66, which is the section where most of your members operate, and then they are given operating licenses under that section. If you look at that section, when you look at Section 66(1)(d), I'm not sure if you have the Act in front of you.
I know pretty well off by heart, but you can tell me what it says and I'll know it.
What I'm trying to understand is, if that Section 66(1)(d) is not creating an exception to the question of the meter, because let me just read what it says.
Sure.
It provides that, let me just read it in verbatim. It says, in the case of a meter taxi service, any particular journey may be operated at a fare not determined by a meter if the fare for that journey has been agreed upon before the journey begins.
Yes, it is the current law.
Yes.
Let's go.
Yes, I'm still, yes. But the meter must be kept running for the information, of passengers. So I'm trying to understand, the way it's been phrased. It seems to suggest, and this is just my preliminary view, it seems to suggest that you can still perform the service without a sealed meter.
Well, what you're going to keep running if you have to perform it without a sealed meter? Sealed meter is a sealed meter. It has to still be running. So that has to still be in the vehicle. I'm not saying that that's how the law says it right now. As it is now, you have to have a sealed meter in the vehicle. So if you're going to take somebody from A to B and you give him a quote of 100 Rand, and you put your meter on and it gets to 140 Rand, well, he's got a bargain, but he can see that it would have been 140 and you made an arrangement for 100. But so that's quite acceptable. But you have to have that meter in the car because that's what the law says, and the meter must be on. There's no escaping at the moment. That's what the law says. So.
Thank you. And maybe just to try and understand, the one guy that you took to, that you objected to his license that you took to the, I think it's the TAT.
Yes.
Just to understand, because you're making a distinction between an e-hailing operating license and a meter taxi operating license. What was issued to this, to this guy that you took to the TAT?
They created what the new Act is doing. The new Act now has got a subcategory called, so it falls under meter taxis, and the new subcategory, 66A, is now called e-hailing. They've preempted that. Whether they saw it coming, I'm not too sure, but they preempted this subcategory. So meter taxi, e-hailing, and then the relevant conditions attached to that. That would be fine if it was post our boss signing the National Act, but up until now, there is no room to have an e-hailing subcategory. It hasn't been created yet. It's going to be created, but it's not currently created.
Thank you, Chair.
Yeah, just a follow-up on that, or on a related issue. Can you talk then about the charter services as to whether or not these e-hailing services are compatible with charter services as contemplated in Section 67 of the NLTA?
No, Chair, under my understanding, and I have read the Act and I know what the Act says, a charter service is a pre-booked service. And you know, I can tell you now that the e-hailings, you cannot pre-book for the next week for an e-hailing service at the moment. It my technology might get there at some point. But the space for charter services has always been a service that was pre-booked. In other words, not 5 minutes before the time. It was a pre-booked service. On Thursday, can you please take our staff from A to B? Not multiple staff stops. I think it actually says that specifically in the Act. You may not stop at multiple points. It's one point to point A to point B. And that is how the pre in the Western Cape actually sees that particular Act. And hence why the pre opted, which we also disagree with, but they opted for the e-hailing subcategory permit when they received that practice note from National Department of Transport. So the charter service, in my opinion, is a pre-booked service which is not 5 minutes before like you would like to see on an Uber or Taxify app. It is a pre-booked service from point A to point B at a given time, a given date, at a given rate.
I have 2 questions regarding to your proposed solutions. And the first is basically with regards to the compensation model that you seem to be proposing. And the question there is whether you see this as dealing with overtrading, or this is dealing with the fact that the minibus taxis, for example, were compensated. So just clarity on that. And then the second one is the point you made about reinstating operating licenses for those that have lost it. Just to elaborate what you mean by that.
Okay, Chair, the first point would be the minibuses. We're not saying, well, I'm not saying is that the minibuses got paid out for the operating licenses. I'm saying is that for 4 to 5 years, we have been subjected to unfair treatment where in the minibus industry, they were told on this route from route A to route B, you want to go from station to C point, we are going to bring in a MyCity and we need you to remove yourselves from that route and we will compensate you for that. There was planning. Whoever owned those routes, they could plan their lives and they know what is coming in a year's time. We've fought against the law. The law tells us this is how it is, and that is our fight. It's not about because they got it, we want it. We're saying is that this could have been handled a lot better, and the effects of this non-legal recognition given to e-hailing and the totally, all spheres of government have ignored us, and that is our fight. It's not about they got it, we want it. We feel that we've been done an injustice, and so many people, I don't know what your second, I'm thinking it was your second question was, that so many people have actually lost their businesses as a direct result, and more will lose in short periods of time, will lose their businesses. And I personally feel that if a guy has succumbed, his business, he's lost his business or his income as a result of this inaction by government in not protecting us and standing by us, it's not difficult to understand. They're fighting massive legal firms and so on, but the law is the law, and they should never have allowed this to come in and override our act. Why must we allow international companies to come in and tell us how to run our act, to the point where they even tell the National Department of Transport what they would like in the act, don't even consult us. They tell us. By the time we got there, the meetings have been done, and it's gone to the lawyers, and 3 years later, we're having a new NLTA. So For me, it was poor judgment, and I think we needed the support, and we needed to be more prepared. And we were never given any opportunities. We were never protected, and that is so. The second question is, and that is why I would like to see people that were affected. If you have lost your licenses, how do you determine that? Well, that's another issue. But if you have you've lost your permits, or you've had to sell them, whatever the reason being, those need to be looked at carefully and said, right, we believe that had we looked after you guys better, you still would be in business. And it's not your fault. It's not your fault that you had to compete with an illegal industry. A fantastic concept, make no bones about it. We'll all be in it one day. We'll all be having these technologies. But we, as the legal industry, we had to conform to what was written in the law, and that's what we've done. And we've suffered because of it, because no one's protected us. And that's what I'm referring to when I say that I think some of those people need to be considered for the return of their permits.
Mr. Drummond, what about the future now?
The future,
With
it's very bleak so far.
it looks like legal recognition
Yeah.
is a legislative policy choice that has been made. Legal recognition of e-hailing services is in the pipeline.
I don't think it shouldn't be seen as a general blanket legal recognition. What the law is saying is that you need to have an operating license to function. I think that's number one on the list. And whether you want to be e-hailing, any taxi should be able to e-hail, telephone, cell phone. It's just a tool of the trade. At the end of the day, we're all taxis. And how you get that booking should be relevant. So I don't think it's a matter of the new legislation accepting. They could always have been accepted from day one. That's not the issue. It's just follow the rules and follow the law. And that's all, as an industry, we are saying is we think that the technology is brilliant. It's technology that we want. And we need, and if that's how we want to compete in the future, that's what we need to have. And but how do you join up with an app company who's got 20, 30, 40, or 4,000 guys behind you competing for your business that you fought so hard for, and you've done it legally, and you've got your operating license, but these other 4,000 on the same streets that you drive in are competing against you? I can't be part of a business. Not that I would join it for 25% either, but I wouldn't be part of a business that, on the one hand, is doing something illegitimate, and on the other hand, we must try to compete. It doesn't make sense to me personally.
Yeah, thank you very much, Mr. Drummond, for your time.
No problem.
Excuse me, as well as for your
No problem.
presentation.
Thank you, Chair.
Thank you,
Thank
thank
you, Commissioners, for your time.
We will. Should we take a break? Or continue? I hear demure of protest. We'll just take a very short 5-minute break, and then take a comfort break, and then we'll take a presentation from Mr. Riaz Mongrati. 5 minutes.